So this week we're going to focus on civil cases. Before spring break we looked at criminal cases, and as we go through our notes that you'll see on your screen, I've got some words that are bolded as we go through. Those are key terms. You're going to be using a Kahoot after all of this to test your knowledge of the vocabulary. Vocabulary is so important in the judicial branch to understand what's going on. So I'm going to really stress the vocabulary. But remember, civil cases are very different from criminal cases. Remember, in a criminal case, you can lose your natural rights or your inalienable rights of life, liberty, and pursuit of happiness. However, in a civil case, that's not true. Civil cases are mainly to settle disputes between people. We're going to go to a chart next to take a look at this, and throughout the presentation here, we're going to reference that chart. It's also connected to the assignment page, so if you wanted to pull that up and look at it a little more in detail, you'll be able to do that because it's in Canvas on the assignment page. It's titled, I think it's titled the Criminal and Civil Comparison Chart. So remember, civil and criminal are two types of law. There's also administrative law that deals with the executive branch. There's constitutional law that deals with the U.S. Constitution. There's international law like treaties. These two types of law are very different in our system of justice. So one of them on the right-hand side there, you see the criminal law. That's going to deal with people who break a law. If you break a law like speeding or homicide, then of course you can face severe punishment. You can lose those rights of life, liberty, and pursuit of happiness. In terms of civil is disputes between individuals. So if you have a problem with somebody, say, not fulfilling a contract or doing something that's negligent, and negligent means that there's something that you should have done that you didn't do, or you didn't do something that you should have. It's not criminal, but it's just usually wrong. And so the purpose, of course, you'll see on your screen here to compare the two, the purpose of civil law is to settle disputes between individuals or organizations, and you compensate the victim. And if you continue to scroll, you'll see in a civil case that a case is going to be filed by a private party. It could be a citizen or a business or an organization, where in a criminal case, the government is going to file the claim in the judicial process for criminal law. That's because you're breaking a state, federal, or local law. For the rights for civil, you see that parties must pay for their own attorney's fees and court costs, where on a criminal side, notice the defendant has the right to counsel. You have all of those rights listed there, like we have in Amendments 5 and 6. You have the right to an attorney, the right to remain silent, you have due process, a speedy trial. Amendment number 4, free from unreasonable search and seizures. So again, Amendments 4, 5, 6, and 8 deal with criminal law. Now, Amendment 7 is going to deal with civil law, but the only thing that says is that you'll get a jury trial in civil cases if the value is over, do you remember, did you say $20? Because if you did, you're correct. If the value is over $20, you get a trial by a jury. Otherwise, if it's under $20, you get a trial by a judge. And we'll come back to this chart, but also notice that it's on the assignment page for civil law. I thought it was a great comparison chart between the two. Okay, so here's the deal with steps to a civil case. I've got a scenario up here at the top. That's not the scenario, that's me. Let's take a look at the scenario right here. And so let's say that you slipped on your neighbor's icy sidewalk and you broke your wrist. And you feel that it's your neighbor's fault that you broke your wrist because he should have or she should have cleared the sidewalk to keep it safe. Is indeed that his or her issue, or is it the responsibility of your local government agency? So his negligence caused your broken wrist. And again, negligence means basically you did something that you shouldn't do, or you didn't do something that you should do. It's not really breaking a law here. And it caused the broken wrist, and you feel like he should pay for your medical bills because, you're not going to send him to jail. So how can you go about filing a civil suit? The first thing that you have to do, and here's a key word right here, is to bring a suit as the plaintiff. So as the plaintiff, you are making the complaint. So do you see how complaint and plaintiff kind of sound similar? You can remember it like that. You're going to hire a lawyer if you so choose. Remember, you're not guaranteed a lawyer in a civil case like you are a criminal case, because again, I'm going to keep repeating this, you're not going to have your inalienable rights or natural rights taken away from you in a civil case. So then you file a complaint with the court, and the complaint, when in a civil case, names the plaintiff and the defendant. So remember, in a criminal case, you have the prosecutor and the defendant. In a civil case, you have the plaintiff and the defendant. And then the court will send a summons. I'm going to actually highlight these two again so you remember that these are the folks that are in the civil case. And then the court's going to send a summons to the defendant telling him about the suit and when to appear in court. The summons is not a request, it's a requirement. You got to get yourself to court. Then once the defendant gets that summons, probably they're going to hire an attorney. But again, do they have to? No, they don't have to, and it's not required they have one. But usually the defendant will answer the summons, the claim that the plaintiff made, and will admit he is or is not responsible for the injuries. So if the defendant says, yeah, look, it's my fault, I was spraying water and I shouldn't have, and it was going to be freezing, I'm going to pay for your injuries, then this whole case is over. But if the defendant says, I'm not responsible for your injuries, then of course, lawyers are going to proceed and discuss the evidence and question witnesses. This is called right here discovery. And so remember, the same thing kind of happens in a criminal case where lawyers from both sides are going to share the exact same evidence and the exact same witnesses. That's your adversarial system of justice, where you're supposed to have two different sides at the same time using the exact same evidence and come to a conclusion. Either the jury or the judge is going to come to a conclusion based on the presentation of the evidence from both sides. So I want to talk about the pretrial discussion that you see over here. This is pre-trial, which means if the defendant says, I'm not responsible for your injuries, before you go to trial, really, the judge is going to try to settle that case. Court cases are expensive, whether it be civil or criminal. So they try to keep cases from blocking up the court system. So the judge may decide to call a pretrial conference. And so at that point, the judge is going to look, and I'm going to highlight that term right there. The judge is going to say, look, to the plaintiff, your case looks weak. You can't really prove this. It's obviously the responsibility of the city to keep the sidewalk clear. So the judge may drop your case. The judge does not have to proceed. They have to accept that case. Or they may urge you to drop it on your own if they don't want to drop it. But if your case looks strong, your neighbor, who of course has this icy sidewalk, the judge may say to the neighbor, to the defendant, look, this is overwhelmingly in favor of the plaintiff, and so you may want to go ahead and settle out of court. And sometimes settlement money is often sometimes less than what the plaintiff is bringing to begin with, and so you can settle out of court. So I'm going to highlight the word right there, settlement, because of course that's going to be how this issue is resolved. Two other terms that are on here, mediation and arbitration. They're subtle differences, but there are differences nonetheless, and I want to talk about those two. To be mediated is where a mediator, it could be a judge or someone of your choosing, either the plaintiff or the defendant, would be appointed to the case, and they would sit down with you as the plaintiff and the defendant and help you to discuss a resolution. And so the mediator is there to help you talk about it, to help you both reach a conclusion. It's like peer mediation, if you've ever done that. That sometimes happens in middle school. A more severe way to decide the case before you get to a trial is arbitration. Arbitration is kind of like what we see with Judge Judy, to be honest. And you're probably going to pause me right now and go look up a Judge Judy case. That's okay. You can do that. Just come right back. So an arbitrator is someone who's more involved in the case. They will sit down and they'll listen to both sides. They'll listen to the plaintiff's side, they'll listen to the defendant's side, and they will make the decision for the case. It is a binding result, and so whatever Judge Judy says is binding in the case. Now both sides have to agree to that, so the plaintiff and the defendant will both have to agree to have their case arbitrated, and both have to understand that whatever that arbitrator decides is going to be the final binding decision. If you'll notice at the bottom, this is pretty significant. Most cases are settled before they even go to civil trial because a lot of people don't want to spend the time and money that it would take to go through a civil trial. Okay, but if the court case is not settled, you know what's going to happen, right? It's going to go to trial. And so this is a civil trial. And so the structure of a civil trial is very similar to the structure of a criminal trial. Just, of course, the outcome is going to be a little different. Remember Amendment 7, got to throw that back in there. Amendment 7 says you can have a jury trial. in civil cases if the amount is over $20, or you could choose to go before a judge only, again, like Judge Judy being an arbiter, and that's called a bench trial. And so that means you just have a trial by a judge, and so there's no jury involved. The judge will determine the outcome. Some people choose to do that because the judge is, of course, experienced in the law. Now, a civil jury can have 6 to 12 jurors. This is like the petite jury for a criminal case, but there's no grand jury that happens in a civil trial. As the plaintiff, just like you have in a criminal case, your side goes first, and so you have opening arguments. The plaintiff can go first. So the plaintiff, in this case, is going to present their evidence first, because the burden of proof is going to be on the plaintiff, like the burden of proof in a criminal case is on the prosecutor. So the defendant can sit there and really not say too much of anything. The plaintiff has to prove that the charge here, be it neglect or some sort of civil issue, that it is their burden to prove the defendant is responsible. Then the judge or jury is going to find either in the favor of the plaintiff or the defendant according to, this is a really strange phrase, the preponderance of evidence. Let's stop here and talk about that. So let's take a look at our chart again, looking at the decision by, again, remember this side is civil cases. The defendant is going to be found liable or not liable, which means responsible or not responsible, based on the, here's that phrase, preponderance of the evidence. That means that the plaintiff, which is the claimant here, must produce evidence beyond the balance of probabilities. So if you looked at all probabilities given for a certain instance or situation, that the defendant is probably the one who's negligent, who's responsible for the issues that have been caused to result in the plaintiff bringing a case, as opposed to on the criminal side over here, where a jury determines guilt or they will acquit the defendant. In a criminal case, you have guilt beyond a reasonable doubt, which means that the person is innocent until proven guilty, and the prosecution has to prove that the defendant is guilty, and that's on a criminal side. Which one do you think requires more proof of guilt, beyond a reasonable doubt or preponderance of evidence? I hope you said beyond a reasonable doubt. In a criminal case, you just have to have that advanced level of proof in order to determine someone guilty. Why is that? Well, it's because, going back to your natural rights, you could have your natural rights stripped from you in a criminal case. It's not going to happen in a civil case. Civil cases set remedies, which mainly deal with money, and not your natural rights of life, liberty, and pursuit of happiness. So again, looking at our notes here, we're looking at right here at point E, guilt to a preponderance of the evidence, which is saying that based on all probability, which is not as much burden of proof as a criminal case, that it's the defendant's responsibility and he or she was most likely negligent. So in the case, if that we have on the scenario for this particular video, if the plaintiff slips on the icy sidewalk, the preponderance of evidence would show that it is the defendant's responsibility, and the defendant, of course, would have a verdict against them to probably pay for the medical bills for the plaintiff. Now, similar to a criminal case, the judge's or jury's decision is going to be called the verdict, and that's going to be, again, their decision. So instead of a settlement, which could happen before when we looked at our notes up above, and I'll scroll up really quickly, where you can settle out of court, you actually, instead of a sentencing or a punishment, we don't really use that phrase in a civil case, you'll have what's called a remedy set. And in this particular case, the remedy could be if you slip on someone's icy sidewalk and it's their fault according to the preponderance of evidence, your neighbor would probably have to pay for your injuries. Now, if the defendant wins, which means that the judge or jury will decide the preponderance of evidence proves that he wasn't negligent, then you get nothing. Then the case is over and you've had, of course, to pay for a civil suit. But at least you've challenged what you thought was the right thing to do. And really, anyone can bring a civil case for pretty much anything. So if you feel like you've been wronged in some way, you can bring it to court. Now, not all cases are even going to make it to court because, as we've said before, a judge can drop that case. And for our last step, let's say the plaintiff, of course, wins, but the defendant lost and felt that the trial was in some way unjust and violated his rights. You can have an appeal. Same thing applies in a criminal case. But the only way you can get an appeal is not because you don't like the outcome. It has to be because in some way, shape, or form, you feel like your rights have been violated. And so the verdict, it could be appealed to the next highest court. Now later on in the next couple weeks, we're going to talk about the levels of the court system. So it starts at the lowest court possible and works its way up to the highest court. And so that could even go up to the Supreme Court, either of the state or the federal government. A case may be overturned by a higher court. And that's where you get into what you guys were talking about with judicial review on your political cartoon. So a higher court can review the case from a lower court. If you're to win the original trial and the appeal, you're going to have to wait until the appeal is over before you get your money. So you have to wait to see if the defendant is going to appeal the case before you could receive your money for your injuries. So again, this particular step, the appeal, has been bolded now, and it is very similar to what would happen in a criminal case. So let's review and test our knowledge by playing a game of Kahoot. So what I want you guys to do, again, when you go to Kahoot, you've got to go in with your first and last name. You've got to be able for me to identify you so I can give you credit. So no nicknames or anything like that. It's what I'm calling you. So if you'll put your first name and your last name. And that's what I need for you to do. And I can't stress that enough. I cannot give you credit for doing the Kahoot if you don't put in your first and last name. No nicknames, no snazzy things like that. Give me your first and your last name. Now, the Kahoot, of course, is going to be not only, you'll see civil case terms, but criminal case terms as well. I want to make sure you're aware of that before you go play the Kahoot. But I want you to do your best. You can do it more than one time. For example, if you want to do it again, just put your first name, last name, number 2. That way I know how many times that you've played that. And if you have any questions about that, you know what to do. Send me an email. Have fun playing Kahoot.